Welcome to our press conference. Notre présentation va être en anglais, mais s'il y a des francophones ici, on va prendre des questions si vous voulez. My name is Sean Patrick Stencil, and I work on nuclear issues with Greenpeace Canada. I'm joined today by Rick Lindgren, a lawyer with the Canadian Environmental Law Association, and Mark Madsen, president of Lake Ontario Waterkeeper. Regrettably, Ecojustice, co-counsel in the case we're about to talk to you about today, and Northwatch, a co-applicant, were unable to join us. For the first time since the 1970s, the government elected on October 6th will decide whether to proceed with building new reactors or instead invest in safer green energy options. There are those who claim that new reactors are needed, affordable, and do not have negative environmental effects on the environment. We're here today because these claims have not been proven. We believe this is in contravention of Canadian law. Last week, Greenpeace, Lake Ontario Waterkeeper, the Canadian Environmental Law Association, and Northwatch asked a federal court to stop any federal approvals that would allow the construction of new reactors at the Darlington nuclear site. We ask for new reactors to be stopped to protect both the environment and the pocketbooks of Ontarians. And we have not launched this application lightly. The Fukushima nuclear disaster has been a global wake-up call on the risks posed by nuclear power. Here in Canada, however, our authorities have pretended that these risks don't exist. In our opinion, the review of the environmental impacts of building new reactors at Darlington has ignored many of nuclear power's risks and costs. It has also ignored consideration of safer and cheaper alternatives to building new reactors. This we also believe to be in contravention of Canadian law. In light of Fukushima, it is more important than ever that Canada's environmental protection laws be respected. And this is especially needed before the next Ontario government makes a decision on whether to okay new reactors or not. Faced with the reality of the catastrophic risks posed by nuclear plants that we're currently seeing in Japan, countries such as Germany and Switzerland have committed to phasing out all of their reactors and to replacing them with green energy. Japan, while still struggling with the Fukushima disaster, has dumped plans for new reactors this summer and passed its own Green Energy Act. Simply put, these countries have decided to eliminate nuclear risks by investing in greener, safer options. Such a consideration of alternatives is fundamental to the concept of environmental assessment and the Canadian Environmental Assessment Act. We're told that we need reactors at Darlington to keep the lights on by our political leaders. There has been, however, no proof of this. The federal environmental review of new reactors did not consider alternatives. And this is part of a pattern that has led us to filing this judicial review today. The Ontario government has shown a systematic pattern, for example, of avoiding any consideration of alternatives to building reactors. When the McGuinty government announced plans to build new reactors in 2006, it also secretly rewrote its environmental review regulations to exempt their plans from a provincial environmental assessment and review of alternatives. Ontario also decided against participating in the federal review panel that we're talking about today to avoid the scope of that assessment being broadened to include alternatives. Greenpeace learned this through access to information. Since 2006, the costs of new reactors have increased dramatically. The government has refused to consider alternatives, however. In the fall of 2010, the provincial government carried out a consultation on its proposed energy policy. The day the consultations began, Energy Minister Brad Good told the media the government's commitment to keeping nuclear at 50% of supply and building new reactors would not be subject to change, despite the consultations. Meanwhile, during this federal review, Ontario Power Generation stated it did not need to demonstrate the need for the project because of the provincial government's policy. This summer, as well, environmental groups asked the Ontario Power Authority if they would consider cost-effective alternatives to building new reactors. The OPA said their instruction from government was to build new reactors, apparently, even if there were more cost-effective options. This failure to consider alternatives is key to why Greenpeace is participating in this application. For the past 5 years, Greenpeace has participated in good faith in provincial and federal regulatory and policy reviews on new reactors. We have commissioned expert advice and pointed to faulty assumptions in government policy. At each step, we have experienced attempts by authorities to sidestep addressing the fundamental risks of nuclear power. On a personal note, I witnessed firsthand this year the impacts of Fukushima and the Chernobyl disasters. Let's say this: nuclear power is an unforgiving technology. We ignore this reality at our own folly. The nuclear power poses an unquestionable risk to the environment, whether from an accident today or from nuclear waste thousands of years in the future. Canadians deserve an open, public, and meaningful review of alternatives and of the alleged need for these reactors. We believe it is their legal right. And with that, I will pass the microphone to Rick Lindgren from the Canadian Environmental Law Association. Thank you.
Thank you, Sean Patrick. Good morning, everybody. As Sean Patrick mentioned, I'm a staff lawyer with the Canadian Environmental Law Association. I'm also co-counsel for the 4 environmental groups who have launched this judicial review application. For the record, I should mention that there are 3 other environmental lawyers who are working with me on this file. Teresa McClanahan of the Canadian Environmental Law Association, and Justin Duncan and Caitlin Mitchell from the Ecojustice organization. In any event, I'm here today to provide an overview of the application. As some of you may know from picking up the press package, the proceeding is an application for a judicial review. It has been commenced in the Federal Court of Canada. And basically, we're asking the Federal Court of Canada to do 3 things. First, we're asking the court to declare that the environmental assessment conducted to date is invalid and unlawful. Second, we're asking the federal court to send the environmental assessment back to the Joint Review Panel for proper completion in accordance with the law. And thirdly, we're asking the court to prohibit or set aside any federal approvals that are needed for the project until the environmental assessment has been completed. Now, these remedies are being requested on several different legal grounds, but the application essentially boils down to 2 main arguments. The first is that the environmental assessment conducted by the Joint Review Panel did not comply with the requirements of the Canadian Environmental Assessment Act. And the second argument is this, that unless and until the environmental assessment is completed in accordance with the Act, then federal authorities, federal agencies have no legal right and no lawful authority to issue approvals for this project at this time. Now, as some of you may know, the Canadian Environmental Assessment Act was passed by Parliament in 1992, and the Act sets out a number of very important mandatory requirements to ensure that all aspects and all environmental effects of major projects are carefully and rigorously assessed at an appropriate level of detail before decisions are made to issue permits at the federal level. And it's our position, it's our client's view, that in this case, those requirements under the Canadian Environmental Assessment Act were not complied with by the Joint Review Panel. Now, in terms of the timeline for the judicial review application, there are a number of procedural steps that all parties must now fulfill. But we anticipate that this application for judicial review should be heard by the federal court in the spring of 2012. So we've got a few months worth of work to go and some paperwork to file before it will actually be argued in court. And that concludes my brief overview of the application. I want to now call upon Mark Matson, President of Lake Ontario Waterkeeper, for some final comments, and then we'll throw it open to questioning. Thank you.
Thanks, Rick, Sean. My name is Mark Madsen, and I'm Waterkeeper and President of Lake Ontario Waterkeeper. My job is to protect Lake Ontario, to protect the lake for the 9 million people who drink from it, the billions of fish that live in it, and the home to tens of millions of people who enjoy the lake. And the reason I'm here today is because despite participating in a hearing process over the course of 3 weeks into the new Darlington nuclear plant, we were unable to effectively protect the lake. The issues were ignored, minimized, trivialized, exempted from the process such as to make it meaningless. This is the first hearing process, environmental assessment hearing process in Canada into a nuclear power plant. It's serious decisions need to be made. We need to know the type of reactors they hope to build at the site, how the cooling water is going to affect drinking water, what contaminants are going to go into the lake, how many fish are going to be killed. We need to hear from experts, not just public consultation. We need effective decision making about important decisions that affect cost, the public, the safety of the lake, the safety of the drinking water, and none of that happened. So Lake Ontario Waterkeeper, along with our friends, are asking the government to change that. A week ago, we asked Peter Kent, the Minister of Environment. And now, as a last resort, we're turning to the courts. We're turning to the courts because it's the courts that ultimately determine whether this process was fair and whether the public was given an opportunity to truly discuss the issues in a meaningful way. And our position is we weren't, and that's why we're bringing the application now. I think, finally, it's important to note that none of us really want to go to the federal court to bring this case of such importance and have to put all our resources and our time and our effort into arguing for a fair and meaningful process. And a lot of people may underestimate the amount of work we put into the hearing, the evidence we brought, the consultants that we tried to get heard. And every one of our consultants said to the panel, we can't go forward with this hearing. We said that on the first day, because there isn't enough evidence to make these decisions. There isn't enough of a file or a record upon which the public can truly have confidence in the decisions that are going to come out of this process. And we're still willing to go into that process if we're given a fair process and bring evidence and discuss the issues in a serious way. And we'll still do that, all of us. But we need the forum to do it. And that's why we're having to bring this application now. Thank you.